Well, good afternoon. Is the fun light on? Okay, come on, Team Williams. You guys know what this means. Is the fun light on?
Yes.
Okay then. How about the rest of you? Are you having fun?
Yes.
Woohoo! Oh, we are so going to hurt that person. Well, this evening, we are blessed that we have two exceptional advocates who are going to demonstrate closing arguments. There's some things that we're going to be looking for in their closing arguments. For the prosecution, we have, of course, a prosecutor, a federal prosecutor, Joe Newman. Let's hear it for Joe. And over here, in the other corner, we have Mike Washington once again defending the rights of the wrongfully accused. Let's hear it. As you're watching their closing arguments, boy, you can tell where my head is. As you're watching their closing arguments, there's some things that you're going to be looking for. We're going to talk about those things in just a second. But first, Professor Zweer has asked me to make an announcement. It has to do with how the witnesses are supposed to work for your final trials. He wanted me to emphasize that you should try to look among the pool of witnesses that you have to try and find kind of witnesses that sort of look like, have the general characteristics of the person that is testifying. What that means is, and here's what that means, every single one of you will be a witness. Okay? You will be a witness. You are obligated to be a witness for the opposing trial. But some of you may actually also be asked to serve as witnesses in other trials. Okay? So you might actually wind up doing double duty. So you might appear in one trial and then leave and go appear in another trial. So just be aware that it's sort of a pool concept, but that does not in any way, shape, or form relieve you of your obligation to be present, accounted for, and be a witness in the final trial that's kind of your corollary trial. You guys with me on this? See how this is supposed to work? And because you are adults, well, okay, with present company accepting, you guys are adults, we expect you to figure it out. Make sense? Okay. Should we talk about closing argument? Some of the things to look for. Here's what I want you guys to look for. Look for the thematic statement, because after this is over, I'm going to ask you guys to tell me, what was the 5-word buzzword? What was the central point of the prosecution's closing argument? What was the buzzwords, the point of the defense? What was kind of their central theme? And look for the circular process. You're going to see they start at one place, they talk through things, and they come back to it. Look for how they use the law and how they argue burden of proof and place burden of proof before you. And look for the 5 crash landings. The 5 crash landings. Because here's the deal. There are 5 things you cannot do in a closing argument. First off, you cannot misstate the facts. You cannot misstate the facts or refer to facts, as we were just talking about in our objection workshop. You cannot refer to facts that actually didn't come into evidence. Okay, so that's the first one. Second one, you cannot misstate the law. You can't invent law. The judge is the ultimate giver of the law, and so you have to abide by the law and correctly quote and use it. That especially becomes dangerous when you wind up sort of playing with and retooling the definition of burden of proof. So listen for that as these guys are talking. Okay? Going beyond the record, going as referring to facts that are not in evidence, misstating the facts of the case, misstating the law. You cannot make an appeal to passion or to prejudice. You can't tell them, the jury, to send a message to a community or make an appeal that is based upon a bias or upon a prejudice. Okay? And I think that's kind of fairly clear. And there's a subset of that. We call it the golden rule. Okay, and that's the 4th one, the golden rule. Under no circumstances, because our courts in this country, in common law courts, view the phrase, put yourself in my client's shoes. Put yourself in the place of, name of a witness or of a victim. Okay? They view that as being essentially an appeal to passion or prejudice. So we call that the golden rule. Put yourself in the place of, can't do it. And the last crash landing is this. It is a statement of personal belief as to the credibility of a witness or the justness of a cause. A statement of personal belief as to the credibility of a witness or the justness of a cause. And the reason why I use that precise language, for those of you that are studies of modern-day ethics, you'll find that language actually in the model code, the model RPCs, CPRs, whatever your jurisdiction calls them. Okay? So those are our 5 crash landings. Now look for those. See if you see those. And more than that, watch how these incredibly skilled practitioners either dance up the line and deliberately make the choice to step across, or dance up to the line and come back. So look for those in these. You guys ready? Fun light still on? Then, ladies and gentlemen of the jury, please give your attention to counsel for the prosecution's closing argument.
May it please the court, ladies and gentlemen of the jury. Beethoven had his 5th, J.D. Salinger, Catcher in the Rye, Joseph Malick, slide please. That's his work right there. That's his work right there. Early morning hours on November 2, last year, right here in Emory City, Megan Lee, a 4th-year student at Emory State, works in a bar as a waitress and dancer to make money to support herself. She has the very good fortune to have a very good night. And when she's cleaning up the last table, she finds under a drink for her 5 $100 bills. Puts it in her money clip, also has her driver's license, and heads home. And the way she goes home, even though it is 2 a.m., is to cut through Park so as to take the most direct route home. A lot of Emory students take this route. She feels comfortable about it. And even though the park is unlit, it just so happens that November 2 is a night with a full moon. So there is some degree of light provided that way. As she's walking in that park, a man comes up and approaches her. And from her experience working in the type of bar where she was working, she knows how to deal with men who might get a little out of line, and her approach is to not look away, not avert, but look them straight on ahead. And the man says to her something like, "Oh, I want you money for a bus," and she tries to step around him. And as she gets past him, he jerks her around, punches her. She ends up, after receiving a few vicious blows, on the ground, where she's also being kicked by him. And he says to her while she's on the ground, in an effort to try and save herself, he says, "Well, I guess he wants my money," takes out her money. Her driver's license is in there. He picks up her driver's license and says, "Megan, that's a pretty name. Maybe you have something more to give me, Megan. Have you ever had meth sex? You're going to love it." And he's kicking her. And she screams, and before she screams, she sees this black knife that he puts right down there in her face. And she sees his sneakers, very unusual. They have, as described in the police report, a black and white checkered pattern. And as she starts to scream, some Emory kids come by, and her attacker takes their money, and runs. Police immediately respond. She needs some medical attention. She's banged up. She gives the police a description of her attacker. She says he was between 5'6" and 5'10", medium build. She describes his apparent ethnicity based on his skin color as being either Mexican or Persian. She said he had dark hair. 2 days later, she's called to the police station to look through some mugshots. She does not pick anybody out. It so happens that the picture of Joseph Malik, the defendant in this case, was in that group of mugshots. And then we move along to some police action on November 17. And on that date, the police have occasion to conduct a search of Malik's residence right here in Nita City, not far from where these events took place. And what do they find? A black knife. The knife has a clip. In the clip, $100 bills. $100 bills. How many? 4. In that search, in addition to the sneakers, the $400, the black knife, they find a very unusual methamphetamine pipe, a pipe suitable for smoking either methamphetamine or cocaine-based crack, and the pipe is unused. The police, continuing their investigation, then call Megan Lee into the police station, and they show her a photo spread. And in this photo spread, there are 5 individuals, and Mr. Malik is one of those 5. She immediately picks him out. The police then conduct a lineup in accordance with proper and fair police procedures, and she immediately picks out Mr. Malik. That is the man who attacked me early on the morning of November 2nd. Those are 2 identifications she made, and there was one more that you heard in this trial. Now, in this trial, the defendant Malik testified, and when a defendant testifies, he testifies like any other witness, and you use the same tests to assess the defendant's credibility as you would any other witness. And one of the factors that the court will tell you to take into consideration is whether that witness has any big blot on their record, any big blemish, such as a conviction for possession of methamphetamines, which Joseph Malik has. And Joseph Malik testified to what in law is called an alibi. That is, the impossibility of the defendant's presence at the scene of the crime at the time of its commission. However, Mr. Malik's alibi has more holes in it than a block of Swiss cheese. He went to a concert with his buddy, Mr. Boulware. More on him later. It's the big Bedlam concert. It goes for hours and hours and hours, all the way to 2 o'clock. And they go together. But they split up sometime, give or take, some period of time around midnight, and they don't see each other. And they go their separate ways in the concert, and they don't see each other for the rest of that night. And Mr. Malik has come into this court and said, "Oh yeah, I got a ride home with Sarah and Grace." I want you to ask yourself a question. Do Sarah and Grace even exist? Are they figments of his desperate, save my butt creativity to get him out of the situation we're in, where the forces are looking like they're going to send him back to prison for a second time, and you can bet he didn't enjoy it much the first time? And he's got an explanation for everything. Mr. Malik does. Oh yeah, my grandmother gave me those $100 bills. She gave me those $100 bills for my birthday, and his birthday was many, many months ago. She gives me another $200 at Christmas. And here's Malik, and he wants you to believe he's sitting on these $100 bills for the better part of a year, where he's lost his job, his car's broken down, which he can't afford to fix. His girlfriend's dumped him, and he's going to be doing his Ben Franklin saving thing with those $100 bills? Not too likely. His buddy Boulware testifies, and he used the same tests for Boulware that you use for any other witness, although Boulware doesn't have a prior felony conviction. But what he has, which is of interest to the case and to your sizing this up, is his ties with Malik. And they go back a long way. In fact, they go back so far that they were both meth heads together. And Boulware even says when Malik went off to prison, it was because Malik got caught trying to score some dope for the both of them. And Boulware said he felt terrible about that. And he did everything he could to make up for it. Ask yourself, is Boulware on the witness stand, as you saw, as you heard, is he trying to make up for that still to this day, doing whatever he can to help out his buddy in a time of great need? The bias of a witness is something that you should always consider. What is the relationship? Is it a neutral witness, or is it a witness that has a prior personal association? And another interesting point that Boulware brought up in his testimony. To go to this fantastic Bedlam concert, the tickets were $100. And Malik was supposed to pay Boulware before the concert. But Malik shows up on the night of November 1st without money. Says they forgot to go to an ATM. And when does he pay his good buddy Boulware the $100 for that ticket? The next day. After the concert. After the robbery. And what does he pay him with? What a coincidence. A $100 bill. Now, in this case, the court, in exercising its discretion on the admission of evidence, has decided to let you hear about an incident that occurred on December 25th involving a Javier Gonzalez, who was involved in another attack on another woman nearby Emily. And his description, or the description of him, roughly approximates the description that Megan Lee gave in this case. But ask yourself this. When the police did their follow-up investigation on the Javier Gonzalez incident, did they find a pair of white checkered band shoes? Did they find a black knife? Did they find 4 $100 bills? And did they find DNA of Javier Gonzalez on the right van sticker of Joseph Nowell? To find the DNA of Megan Lee that Dr. Diaz says there's only a 1 in 960 chance 1 in 960 Caucasian individuals would have the same chance of having the same DNA as Megan Lee on that right sneaker. That right sneaker, that DNA evidence, it doesn't establish Joseph Malik's guilt. If that was all there were in this case, the prosecution would say, you don't have enough, take it and go. But we've got so much more in this case. And what that DNA evidence absolutely does is it blows up the red herring of Javier Gonzalez as being any type of proof of Mr. Malik's innocence. It just isn't there. Now in this case, Miss Lee did not mention the facial hair that Joseph Malik had. And one could say that given the traumatic attack that Megan Lee suffered, and you know from having heard the testimony in this case that Joseph Malik was also a would-be amateur boxer, went to the gym regularly. What does a boxer do in a gym? He hits a heavy bag and he hits a speed bag so he can inflict punishment with his fists. Did he do a good job there? You decide that. And then when you consider the hard scientific or the hard police work in finding the corroborative evidence, such as the Van shoes, the black knife, the money clip there, and the meth pipe, that ties it all together. It ties into Megan Lee's description of the attack, and it absolutely throws off this rabbit trail that the defense has tried to put in for you to run and chase down involving this Javier Gonzalez. No, it's Joseph Malik. It's Joseph Malik. And remember, reasonable doubt is a doubt that arises from the evidence, based on reason and common sense. It's not vague, speculative, or imaginative, but such a doubt that as would cause reasonable persons to hesitate to act in matters of importance to themselves. This is a matter of importance, and you will recall when you came into this room, you were not asked to check your common sense on the way out. Prosecution submits that the guilt of Joseph Malik on the 3 charges before you, armed robbery, aggravated assault, battery, and you've seen the deadly weapon, the knife. You know the money that was taken, and you saw the injuries to her. The prosecution has proved its case here by the standard of proof beyond a reasonable doubt. It's not proof beyond all doubt. It's not proof to a mathematical certainty. It's the proof as I described to you a moment ago. Thank you for your attention.
Ladies and gentlemen, please give your attention to counsel for the defendant.
If I can have just a moment, Your Honor.
Of course.
She was certain, but she was wrong. 2 o'clock in the morning on November 2nd, when Megan Lee was being attacked in Emory Park, Joseph Malik was riding home in a car with Sarah and Grace, two women he had met after a concert he attended. You now know that from the evidence you've heard in this case. Megan Lee says, no, that's not true. Joseph Malik was in the park with me. She's certain, but she's wrong. As I was preparing this case, I was reminded of a situation that happened to a friend of mine just a couple of days ago. He went out to lunch with some friends of his, and as gentlemen do here in Emory City, took his jacket off at lunch, and so did his colleagues. And they had lunch together, and they all got up and started talking after lunch. And then when it was time to leave, the gentlemen all grabbed their jackets and walked out. And my friend, he was the last to leave, and he noticed that there was one jacket left, but that jacket wasn't his. And so he looked at it, and he thought to himself, and he said, well, obviously, it's just a mistake. Someone selected my jacket thinking it was theirs. So he looked at the jacket, and he tried to figure out who this jacket belonged to. And when he saw his colleagues later at dinner, he went up to that person and said, hey, I'm just telling you, I think you might have grabbed my jacket by mistake at lunch. And the guy said, sorry, I don't have your jacket. I took my jacket for lunch. I know what's in my closet. And so my friend sat there and said, well, let me ask everybody else. And everybody else said, no, I've got the jacket I was wearing at lunch. I don't have your jacket. So my friend went home that night, and he said, well, let me just double check my closet and see what I have there. And he opened up the closet, and he had my friend's jacket in his closet. And so the next day when they got together again, he went up to him and said, you know what? He did the right thing. He said, I'm sorry, I made a mistake. Our jackets look similar, but I've got the wrong one. Let me give you your jacket back. That man was the prosecutor in this case, Joe Newman. He was certain, but he was wrong.
Outside the evidence.
Sustained.
But enough about Mr. Newman. Let's talk about Miss Lee. Miss Lee says she got a good look at her attacker because she knew when someone grabbed her on the arm that something wasn't right, and she wanted to take a nice, good, long look to let that person know she wasn't backing down. She was standing up for herself. There wasn't any street lights at the park, but there was moonlight, and it was a full moon here in Emory City, and she could see clearly. And so she was attacked, and she gave a description to the police of her attacker. And here's the thing. And you've seen it all through the trial. You've looked at Mr. Malik. If there's one thing that's distinctive about him is he's got a full beard. It's not scraggly. It's not weak. It's the one feature among all of his features that you notice first. But here's Miss Lee talking to the police the night of her attack. She doesn't say anything about her attacker having a beard. She gives a lot of detail, but nothing at all about a beard. So Detective Novak and the other police get together, and they take her and they show her a series of mug books. And because she doesn't say anything about her attacker having a beard, they show her pictures of all sorts of guys. Some with beards and some without. Why? Because she hasn't said anything at all about facial hair. And one of the pages in one of the mug books is Exhibit 5. As you saw, there's only one guy that's got a nice, full beard that stands out in that page. And that's my client, Mr. Mallett. So she looks at that page amongst the other books that she looks at, and she tells Detective Novak, I don't see him. I've looked at the books that you've got here. My attacker's not here. So a couple weeks go by. And they decide, you know what? We're going to bring her back to the station. And you heard what had happened. They now had Mr. Mallett. So they took his picture and placed it with others. And Detective Novak said, well, you know, I was trying to put it with people that looked like him. And if you're like me, you looked at that series of photos and said, really? Because once again, there's only one guy that's got a nice full beard in that group. And that's the person in picture number 1, Mr. Mallett. And so we looked at, with Miss Lee, what she had to say when she saw that group of pictures. And she said, well, number 1, he looks familiar. Well, yes, he does. Because she had seen his picture before. And in fact, what she said and what she admitted to you folks was, what I said was, I recognize the beard. Why? Because in these 2 photographs, the most prominent thing is Mr. Mallett and the beard. She was certain that she had picked the right man, but she was wrong. She was wrong because the police, you now know, captured her attacker in December. Javier Gonzalez was a man who the police know, who you all now know, likes to beat, assault women near Emory Park, and he does it with a knife. Well, I know you're thinking, but she didn't pick him out. And we know why that is now. Because she had already made her selection. She knew what was in her closet. She had picked already. You couldn't show her another picture. I picked the guy already. That's Mr. Mallett. I'm certain now it didn't matter to her. The police, Detective Novak told you, didn't even tell her. This is a guy that did the exact same thing to another woman in the same place, just weeks apart. But it's not just Javier Gonzalez, because we actually called witnesses on the defense. We talked in voir dire that the defense didn't have to call anybody. But Mr. Mallett wanted to tell you folks himself that he didn't commit this crime. And he had 2 people testify on his behalf. One was his friend, and one was his mother. Now, Mr. Newman would have you believe, well, come on, you're going to take their word for this? Mom took the stand? Yeah, Dr. Mallett took the stand on behalf of her son. And yes, she loves her son, and no, she doesn't want to see him go to prison. And she told you this about him. She saw him that night before he went to the concert. He didn't seem depressed. He didn't seem distraught. He didn't seem like he was on drugs. He was looking forward to the evening. And she saw him the following morning when she woke up and he was normal. And she told you she knew about his history with drugs, and so she wouldn't have been on the lookout for anything like that, especially since he went to a concert, and she didn't see any signs of that. In fact, the police told you they didn't find any drugs in his house at all. But that's just Mom. Let's talk about his friend, Greg. Well, Greg told you, I've known him since we were kids. And yeah, we did drugs together, but we've moved beyond that now. And so we went to the concert, and Greg told you he paid for the ticket. And he wasn't worried about getting paid for Mr. Mallett. That wasn't an issue for him. There was no pressing need to get that $100 the night of the concert or the following day. And he told you when he saw Mr. Mallett that day, he seemed fine. He told you he got a call from Mr. Mallett at 2 o'clock that morning saying, you know what, you don't have to wait for me. Got some people that are going to give me a ride home. And he said when he saw Mr. Mallett the next day and Mr. Mallett gave him the $100, he seemed fine. Well, in order for Mr. Mallett to be guilty, Dr. Mallett and Gregory Bulwer must be lying to try to cover for him. Let's accept that as true, that that's what's going on. Are these the lies that they would tell? They would lie to each say, you know what, I saw him before the concert, but I never saw him after the concert. That's how they're going to protect him? That's how they're going to keep him out of prison? By saying, I wasn't with him during the time this crime was committed? If they were going to lie, they would lie to say, Greg would say, you know what? I saw him after the concert. We were never separated. I gave him a ride home. Why? Because I got his back. So Mr. Newman wants you to believe that because he feels responsible for Mr. Mallett's past brushes with the law, he's somehow lying about this. But his lie would be complete, because no one would be able to contradict it, except for Miss Lee. And as my client's mother, Dr. Mallett, would say, you know what? I was waiting up for my son. I spoke to him when he got home. He got home about 2:05. I remember there were two young ladies that dropped him off in a white Honda Civic. The alibi would be complete if they were trying to figure one out for him. The reason why it's not complete is because they came and told the truth. They weren't with him, but they do know him. And they know that he's not the type of person that would have done this thing. And you now know who is Javier Gonzalez. Let's talk briefly about the law in this case. And we talked during voir dire about the fact that because this is a criminal case, it's got a different standard than we see in most cases. Most cases are civil cases. That's what we do in life. We just weigh them. Do we like one side better than the other? If so, that's why I vote. Just has to weigh a little bit on one side that has the burden, they win. Mr. Newman knows that's not what his burden is today. His burden is to prove his case to you through the evidence beyond a reasonable doubt. What does that mean? Well, it means a doubt based on reasons. That I can't stand up here and just say, well, you know what? Somebody could have come down in a spaceship and committed this crime on Miss Lee and that looked just like Mr. Mallett and then disappeared, and that's why he didn't commit the crime. That would be fanciful. That would be vague. That would be imaginary doubt. But the doubt in this case is based on the facts. It's based on the evidence, most of which was introduced by the prosecution. That there's a reason why Miss Lee misidentified Mr. Mallett, because of the way they did their procedures. And there's a reason why Mr. Mallett's not the person that committed this crime, because he was nowhere near Emory Park. Mr. Newman told you that Mr. Malik had a motive to commit this crime, this theft, this robbery of Miss Lee. He's out of work. And obviously that means somehow, supposedly, he needs the money. All right, let's assume that that's true. What happened? Mr. Malik goes out to a concert with friends and thinks to himself, you know what, I got to figure out a way to get away from Greg so I can go to the park where people walk freely and somehow find somebody that's going to be walking by themselves that's going to have a couple $100 that's an unusual tip for the night, and then beat her up and then have her take her money out and hand it to me so I can get away with it. Well, let's assume all that's true then. And the reason why I'm doing this crime is because I owe Greg $100 and I got to pay him by tomorrow. So I'm going to give him the $100. And you know what? I got debts. My car needs to be fixed. But I'm just going to take $400 and fold it up and put it with my knife. I'm not going to spend it on anything. Because that's the evidence. If Mr. Malik was the attacker, he did all of this to give his buddy $100 and hang on to the evidence of his crime until the police would one day figure it out. Because he didn't spend it for car repairs. He didn't spend it to take himself out to dinner. He didn't give any to his mom to say where the money came from. He didn't buy any drugs with it. He was desperate for money that he could keep at home, folded together. Because that's what he did if he was the attacker. It makes no sense. Because he's not desperate for money. Greg Boulware told you that. Dr. Malik told you that. He didn't need the money, and he didn't need to try to get it this way if he needed money. When you go back to deliberate on this case, you're going to get a jury verdict form. It's got 2 pages. The first 2 charges are this: armed robbery and aggravated assault. And as you notice, I haven't even talked about the elements of these crimes, because I'm not saying that Mr. Malik did something to Miss Lee, but it just wasn't aggravated assault or just wasn't armed robbery. If I wasn't clear, let me be so now. Mr. Malik did not commit this crime. When you get back to deliberate, the part on this form that you fill out is we find the defendant not guilty of armed robbery, not guilty of aggravated assault, and finally, not guilty of battery. Now, in just a moment, Mr. Newman's going to get a chance to get back up, because the law gives him that permission, because they recognize that prosecution has the burden of proof. But before he does that, and realizing I don't get a chance to go again, whatever he says is the last word, I'm going to ask you to see if he can answer a couple questions. If poverty is Mr. Malik's motive, how come he didn't spend the money? If drugs were the cause, how come they didn't find any drugs? Yeah, they found a meth pipe that no one has ever used. And if lying is what the defense witnesses did, why didn't they tell a better lie? You already know the answer to those questions. It's because Mr. Malik did not commit these crimes. Megan Lee was assaulted by a man that we now believe is Javier Gonzalez, but we don't have to prove that. They have to prove that Mr. Malik did this, and they haven't. I thank you for your time.
And I believe the prosecution has waived its rebuttal due to the lateness of the hour. Sadly, that was louder applause. titans clash, you hear thunder. Did you guys hear the rolling phrases that were coming from Mr. Newman and from Mr. Washington? Did you hear the rhythm? And did you hear the power of the words that they chose? Did you guys hear that? Now, Joe, let me ask you, that rhythm that you had going when you were saying, and the way she goes home, even though it's 2 a.m. Did you guys notice that rhythm? That rhythm, was that something that you're doing deliberately?
First thing I have to say is, I'm so glad that that man lives on the other side. And it stays there. No, it's probably just a function of a New York, Georgia cross life.
You also heard that same sonorous, but also very precisely timed rhythm by Mr. Washington. Mike?
I think I talked to my group a little bit. I want to go at a pace that the jury can hear and almost echo my words back as I speak, because then I know I'm going slow enough that they can appreciate what I'm saying. It's a pace that's used a lot by old Baptist preachers because it's persuasive, and my grandfather was one. But it's a persuasive cadence because it gives you time to get that sense of, I'm following you, I hear what you're saying.
You know, I just want to echo what Michael said there. I'll occasionally be doing some channel surfing on Sunday morning, come across some of these almost evangelistic type ministers, and they have the same gifts that great lawyer advocates have. And the more outlandish, you know, the pitch, almost the more interesting it is from a rhetorical construction. And you really would actually benefit if you intend to do some trial work, and particularly criminal work, which has a much higher emotional content than civil cases, to watch some ministers perform like that, because there are some great rhetorical lessons found there.
Did you notice Joe's use of his body? And he jerked her around. Remember that gesture he made? You could just visualize it, couldn't you? It really drove home this image, this visual image. Joe, you put her picture up there, and you left it up there. Why did you do that?
Cheap shot.
And Mike, first thing you did is you walked over and you made sure that thing was shut down. Why?
I was hoping he'd shut it down during the middle. I was glad that he went to the shoes and other things, because that's a nasty picture. And someone's going to pay. I mean, that's what the jury's thinking. She really got beat up. Someone's going to pay. And there's only one person on trial there, so that's my concern. They're going to make my guy pay just because someone's got to.
You used an interesting rhetorical device, and that was the questions, those 3 questions. Why did you choose to do that?
Because I know I don't get the last word, and what I want to do is bait him into talking about the stuff I want him to talk about. The last thing I want him to do is decide to get up and just reaffirm his information. So I'm going to try to set up a straw man that either he gets to ignore, and the jurors go, well, he didn't even answer those. That must be because he can't answer those. Verdict, defense. Or he spends time trying to answer those, in which case I've got him off his game. I've got him playing in my side of the field.
One of the most common mistakes we see advocates make is getting sucked off their case theory, right? So, Joe, what would you do with that?
I thought there wasn't going to be a rebuttal argument here, but sometimes in some arguments, if I know, I have 2 arguments, and I'll do that, what Michael did here. And it's easiest to do from a prosecution standpoint, where the defense has put up evidence and the defendant has testified. It's so constraining for a prosecutor to argue in a case where the defense has put up no evidence and rested, because there's so many things you could say that would cause an instant mistrial, and that's not a good thing.
So you would just waive your rebuttal?
No, I never waived my rebuttal. But in this case, what I would have done when I got up is I probably would have maybe touched on his questions at the very end, but I would have pointed out that counsel didn't say anything about the DNA evidence. Counsel didn't say anything about Van white and black checkered shoes. Counsel didn't say anything about that black knife. And then just maybe 1 sentence on his rhetorical questions. But I wouldn't have started out addressing that at the front end, because that would be just like Matt and Michael said.
So shift the game, it's not that you ignore it, but shift the game back onto your turf.
Right.
Okay. You know, there's two sort of interesting, contrasting things that the advocates did here. Joe used this really interesting phrase, the court, having exercised its discretion to let you hear certain evidence. Do you remember that? Okay. And then later, you heard Michael use this other sort of interesting convention, and that was, well, let's assume that that's true. And then sort of go through the, what would be the Latin phrase for that, where you just take it to the
I didn't go to school here.
some of those kids we had here earlier today would be able to answer that. But just to take it to its absurd conclusion, did you notice those two sort of interesting rhetorical devices?
Reductio ad absurdum.
I'm sorry?
Reductio ad absurdum.
Reductio ad absurdum. I knew somebody in this room was going to know. Being from Nebraska and all. Except for rely upon you and Lance that got you through. But did you notice those two devices? Can you see how they were used so effectively? But let me ask you this: can they go wrong?
Of course. If by setting up a scenario, the jury believes, yeah, I think your client would be that stupid. He would hang on to $400. That's the only evidence. And the shoes and the knife, because he thinks he's that slick or clever or stupid that he would do it. Yeah. So it can have jurors go, yeah, we think he said that.
Now, you referred to the court in its discretion having allowed you to hear certain evidence. Why did you do that?
Because I thought the court made a bad decision. And I told our red section students that I didn't think the court would admit that. But, and I understand the rules for the trial are, as announced today, that is coming in. Those students, the prosecution students, do have to deal with it.
So in that context, it's one of those things where, well, okay, was your intent to heighten the credibility of that evidence or diminish it?
Diminish it, I hope.
And now let's talk about themes. I mean, we had two very clear themes here, didn't we? Okay. What was Joe's? Remember I said I was going to ask you. What was Joe's?
That's his work.
Yeah, this was his work. Right? We started with Beethoven, with J.D. Salinger. Some of us were going, J.D. who? But clearly this was his work, and then he left the photo up. And then we had the wonderful analogy of the quote. And you remember the phrase, she was certain, but how many times did he say that? Yeah, I counted 13. Really, and he pulled that all the way through at key moments. Not so it became obnoxious, but at key moments. So let's talk about that wonderful analogy that was, and the objection of the coat. By the way, you should know, it's a true story.
It's a true story, except for one thing. When I got in the van and Matt brought this up,
Because it was by coat.
I said, I don't think so, but I'll check when I get back to the motel after dinner. Isn't that what I said?
Close.
I never said I'm absolutely certain I do not have your coat.
Well, bottom line though is, wasn't that an interesting analogy? And you'll notice that the analogy went on for a while, didn't it? The analogy of the business lunch and the people, and they left their coat and they picked up their coats. And Joe didn't object. Joe, why did you wait to when you did to object?
I thought it would be bad form, and I thought Michael was doing that as an exercise of how far you can push the envelope and maybe do something arguably improper. In a real case, I don't think Michael might have used that analogy, but he wouldn't have used me by name.
And why? Because that was where he crossed the line, right?
Right. Because
By the way, we planned that, just so that you know.
please, I wouldn't have done that. Frequently, defense attorneys will, in voir dire in a case like this where it's identity, they'll say to the panel of jurors, has anybody here ever seen someone when you're walking in the mall and you call out, hey Bob, and you get up closer to him and you realize it wasn't Bob? You know, that type of stuff. And well, he was just doing a little more grandiose version of that.
But the moment he made it about something that had actually happened, not just a story, not just sort of a kind of common thing that happens, but something that was actually real that involved you, he actually was bringing in, and what did he do? He violated one of the crash landings, and he noticed what the objection was. Facts not in evidence, right? And so that was the place where he crossed the line. So we want you to get the idea. Analogies are good. Stories, great. Problem is, one, make them quick, make them clean, but also don't bring in things that are not in evidence. Make it personal, because then you get into the whole issue of actually attacking opposing counsel, which I don't think that was your intent.
Well, when you told me that I should put Joe's name in there, that was...
Yeah, that was. and I did eventually get my coat back. Actually, I will tell you, he called me up, and this was his exact words on the phone. This is the Blue Coat Delivery Service. Are you in your room, Mr. Williams? And he did bring it to my room, so thank you. At any rate, thank you for your patience, and thanks.